I've mentioned in past videos about habeas corpus or habeas corpus, um, but somebody in the comments said, well, this is all very interesting, but what does it actually mean? I think that's a sort of, great question because it's a phrase that gets bandied around a lot. But yeah, what exactly is it? Okay, let's look at the origins of this. The concept behind it has been around for a very, very long time, and we'll shortly look at the history of this. But effectively, it's to address a particular issue, which is this. Imagine that you have been detained by the state. You have been put in custody, and you just don't know why. You're not sure what's going on. Or you've been arrested, and your friends are worried about you. They've not heard anything from you. They don't know what's going on. So there is a procedure where you can apply for a particular type of writ. And that compels whoever is holding the person, or you, to produce you actually at court. First of all, just to check that you're still okay, you're still alive, you still exist, nothing's happened to you. But also the detaining authority has to come along and say, this is why we are detaining somebody. They have to show that there is a reason to do that, okay? The phrase itself, habeas corpus, actually means show us the body, produce the body. Okay, so the full phrase, I actually had to write this out phonetically, but it's habeas corpus, coram nobis, ad sub judicendium. And that actually means you have a person before you, or us, for the purposes of bringing somebody forward for a case to be examined. So that's explicitly what it means in the original Latin. But this dates well before Latin. I mean, there is a reference in Magna Carta to the idea that, there needs to be what the Americans would call probable cause or reasonable suspicion. But that does seem that it was just reflecting a pre-existing right and remedy. One interesting thing about the reference in Magna Carta is that it explicitly states that it applies to everybody, not just freemen. Now, we see this in Magna Carta where it's like, no freeman can be detained or can be tried without a jury of his peers and things. But it is worth remembering that at the time, freeman was a specific status that didn't apply to everybody. I mean, a lot of Magna Carta was almost like a private dispute between the barons and the king. And if you actually read half of it, it's stuff about like fish, putting fish weirs in the Thames and stuff. It didn't really apply to your common serf. I mean, they were barely one step above slaves for quite a lot of history. But interestingly, Magna Carta explicitly says that this applies to everybody. The first real attempt at codifying habeas corpus was the so-called Assizes of Clarendon in 1166. And actually, the Assizes of Clarendon are probably worth a video on their own. But Henry II, as king, wanted to set out everybody's fundamental rights and just clarify the law a little bit. So obviously, that very much predates Magna Carta itself. Now, one aspect of how habeas corpus applies in England and Wales, and the sort of UK generally, as opposed to, say, on the continent, is how common law systems and civil law systems approach cases generally. And it's very well established that in English law, you need at least a prima facie case or reason before you detain somebody. Now, that's different to in civil law jurisdictions where you can be detained on, pending the gathering of evidence. So that, it's like, well, we think this person might be involved. We will detain them and question them and keep them, an eye on them and keep them in one place while we investigate whether there's a crime being committed. That's very, very different to here. Now, obviously, when people have been arrested and charged, there is still evidence gathering may go on, but there has to be at least initially a prima facie case. You can't detain somebody pending an investigation. Now, we'll see, of course, that the law does reflect that, even the modern law. For instance, if you are arrested, and the police need, at least reasonable suspicion to arrest you, there's certain limits on how long you can be questioned. The custody clock, as we call it, and effectively it can go up to 72 hours actually with applications to magistrates and things. You might remember there was that proposal a few years back that it could be extended for weeks or even months, but that's very much been rejected and abandoned now. But that's one of these things that shows. I mean, the reason we don't hear a lot about habeas corpus in this country is a lot of the problems that habeas corpus seeks to address have been dealt with by specific legislation. So, say, for instance, when you're arrested, there is the custody time limit clock. The fact that you are allowed to notify somebody of your detention, save in very exceptional circumstances where they think that might, impede an investigation or tip off, somebody. Um, that they're about to be arrested or something like that. Similarly, we have bail applications, we have first appearances at the court. At every stage in proceedings where you are detained, there is usually a remedy, a statutory remedy, such as the Bail Act, where you can challenge your detention or at least ask them to put forward the reasons for your detention. But this writ still does exist. The most recent use that I'm aware of, but this might be just because of sort of, my areas that I'm interested in, is it was used in relation to the detention of prisoners in Iraq and Afghanistan, especially when they were sort of seized by special forces and then they may have been handed over to the Americans. And again, as we know, there were sort of black sites and things like that, and people went into sort of judicial limbo. And people did actually, it was an organisation called Reprieve, they did actually bring a writ, apply for a writ of habeas corpus to find out what happened to people who'd been seized by the military and had pretty much just, gone into the ether somewhere. The actual cases in the end, they said, well, when the court said we're not going to get into the politics of this, the Secretary of State has signed off and said, yes, this is okay, and we have a memorandum of understanding with the Americans, and I'm sure they'll all be treated properly, and I'm sure there's a judicial mechanism there that they can use. So the actual application was unsuccessful, but it showed that this still exists. And actually, there were two dissenting judgments. I think one of them was Lady Hale actually, who said no. This is exactly what habeas corpus was, designed to do. So, let's get these people within the jurisdiction so that they have all the protections of the law, and we can have a proper investigation as to why they're being detained, whether there are grounds for detaining them, and if so, how long they should be detained and what's going to happen to them next. I think the first time that the sort of phrase was actually used in legislation was in about 1679. There was an Act of Parliament then, just again setting out sort of everybody's sort of rights and remedies, but it was very much reflecting, what was the current practice. So how do you actually go around? How do you actually apply for one of these? It's just done as what we call a Part 8 claim. So you just you just download the standard Part 8 claim form and you set it out there. Now, ideally, it's the person who's detained who seeks habeas corpus, although that's obviously not always practical. But you put in the application, though, and they have to be done on evidence, so somebody has to do an affidavit. So I'd like to say, ideally that would be the person being detained, but the courts recognise that's not always practical, so it could be somebody on their behalf. And this is what's interesting. What we call standing to apply for a writ of habeas corpus is quite wide. Standing, or locus standi, to use the Latin we're not supposed to, that is the ability to bring a case. Now, obviously, if somebody runs you over, you have standing to bring a case. But what if it's something you're not directly involved in? I mean, interestingly, for instance, and to sort of get back to sort of like trees and nature and things like that, there were some issues. Do Greenpeace have standing to bring judicial review about sort of government decisions that affect the environment? And there has been a shift now. Originally, it was no, you don't. You're not directly affected. There has been a shift now where the courts are sort of widening standing. And all our cases where we're applying for things on behalf of animals, including writs of habeas corpus. But generally speaking, it could be your friends, your family, or it could be a campaigning group. Like I say, Reprieve brought the applications on behalf of sort of detained prisoners, and there was no dispute that yes, they had standing to do this. So, if you ever find that you need to apply for a writ of habeas corpus, that's all dealt with by Part 87 of the Civil Procedure Rules. Everything's set out there. It's fairly straightforward, to be honest. It's just, stick in the Part 8 claim form and an affidavit, because effectively all you're asking is you're saying, look, somebody has been detained and we'd like to know why. Reasons that might be rejected, it might be there's another remedy that the person can do. Like I say, you've got bail applications, you've got reviews of detention and things like that. So, there are lots of mechanisms there that have the same effect as habeas corpus. But yeah, it still exists. So that's very much an overview. It'd be quite interesting to talk. It's one that's used a lot in the United States, actually. Also, it's probably worth mentioning that habeas corpus has been suspended a few times. I made that joke about, how there's people like myself who are also very woke, SJW, but as soon as somebody, because of the animal rights, as soon as somebody looks at a dog funny, it's kind of like, you want to suspend habeas corpus. That's actually happened. It happened in the 18th century when people were worried about sort of insurrections and riots and revolutions. Also applied, though, you might remember when there was internment in Northern Ireland. So habeas corpus was effectively suspended then. I mean, it is considered to be sort of very much a last resort because effectively you're authorising detention for no reason. It's authorising arbitrary detention. So that's why, suspending habeas corpus is always seen as sort of, a line in the sand. But there you go. As always, hope you found that vaguely interesting. I think that's my new current sort of marketing thing, expectation management. I just seek to be vaguely interesting. If you did, please click the like button. Also, if you could subscribe, and people keep telling me to say this at the beginning of the video, but I always forget. But there you go. Hope you found that useful.